Hello everyone. This is Dr. P. Kokila, Assistant Professor, Department of Commerce from St.Josephs College of Arts and Science for Women, Hosur. Today we are going to learn about contract of agency. When a person employs another person to do any act for himself or to represent him in dealing with third person, it is called as a contract of agency. Definition of contract of agency. To simplify Section 184, an agent is a person who is employed to bring his principal into contractual relations with third parties. But during the period that an agent is acting for his principal, he is clothed with the capacity of his principal. A contract of agency may be express or implied, but consideration is not an essential element in this contract. The relationship of the principal and the agent is fiduciary. Classification of agents. There are three classes of agents: general agent, special agent, and mercantile agent. Let us discuss the classification of agents in detail. Special agent. A special agent is one who is appointed to do a specified act or to perform a specified function. For general agent, a general agent is appointed to do anything within the authority given to him by the principal in all transactions or in all transactions relating to specified trade or matter. The third party may assume that such an agent has power to do all that is usual for the general agent. An universal agent authorized to do all the acts which his principal can legally do. Classification on the basis of work performed. Mercantile agents. A mercantile agent having in the customary course of business as such agent or the authority either to sell goods or consign goods for the purpose of sale, or to buy goods or to raise money on the security of goods. Brokers. A broker is a mercantile agent whose ordinary course of business is to make contracts with other parties for the sale and purchase of goods and securities, of which he is not entrusted with the possession for a commission called brokerage. He acts in the name of principal. He has no lien over the goods as he is not in possession of them. Factor. A factor is a mercantile agent employed to sell goods which have been placed in his possession or contract to buy goods for his principal. He is the apparent owner of the goods in his custody and can sell them in his own name and receive payment for the goods. He has an insurable interest in the goods and also a general lien in respect of any claim he may have arising out of the agency. Del creditor agent. A del creditor agent is a mercantile agent who is consideration of an extra remuneration guarantees to his principal that the purchasers who buy on credit will pay for the goods they take. In the event of third party failing to pay, the del credit agent is bound to pay his principal the sum owned by third party. Auctioneer. An auctioneer is an agent who sells goods by auction, that is, to the highest bidder in public competition. He has no authority to warrant his principal's title to the goods. He is an agent for the seller, but after the goods have been knocked down, he is agent for the buyer also, for the purpose of evidence that the sale has taken place. Banker. The relationship between a banker and his customer is primarily that of debtor and creditor. In addition, a banker is an agent of his customer when he buys or sells securities, collects checks, dividends, bills, or promissory notes on behalf of his customer. He has a general lien on all securities and goods in his possession in respect of the general balance due to him by the customer. Non-mercantile agent does not usually deal in the buying or selling of goods. Non-mercantile agents are advocates, attorneys, wives, etc. Creation of agency. Agency system is very popular in the current business scenario. There are two parties in the agency system. One is the principal and another is the agent. The agent is a person acting on behalf of his principal. It is a connecting link between the principal and the third party. What is express agency? A contract of agency may be made orally or in writing. The usual form of written contract of agency is the power of attorney, which gives him the authority to act on behalf of his principal in accordance with the terms and conditions therein. In an agency created to transfer immovable property, the power of attorney must be registered. A power of attorney may be general, giving several powers to the agent, or special, giving authority to the agent for transacting a single act. Implied agency. Implied agency may arise by contact, situation of parties, or necessity of the case. That is, agency by estoppel, agency by holding out, and agency of necessity. Duties of an agent. These are the various duties of agent in a contract of agency. An agent must act within the scope of the authority and carry out strictly the instruction of the principal. In the absence of express instruction, he must follow the customs prevailing in the same kind of business. He must to do the work with reasonable skills and diligence. He must disclose promptly any material information coming to his knowledge which is likely to influence the principal in the making of the contract. He must not disclose confidential information entrusted to him by his principal. The agent must keep true accounts and must be prepared on reasonable notice to render an account. He must not make any secret profit. He must disclose any extra profit that he make. Rights of agent. The agent becomes entitled to receive remuneration as soon as he has done what he had undertaken to do. To retain his dues, he has the right to stop the goods in transit where he is an unpaid seller. To have a lien. As the agent represents the principal, the agent has the right to be indemnified by the principal against all charges, expenses, and liabilities properly incurred by him in the course of the agency. Termination of agency. An agency is terminated by the principal revoking his authority or by the agent renouncing the business of the agency or by the business of the agency being completed or by either principal or agent dying or becoming of unsound mind. Next, by the principal being adjudicated and insolvent under the provision. Agency is irrevocable. Where the agency is coupled with an interest, it does not come to an end, even in the case of death or insanity or insolvency of the principal. When an agent has incurred personal liability, then the principal cannot revoke the agency. The agency becomes irrevocable in nature. Thank you very much.